Hello, and welcome to Taking Algorithms to Courts, a relational approach to algorithmic accountability. I'm Jacob Metcalf, and I'm presenting this on behalf of my co-authors, Emanuel Moss, Ranjit Singh, Emnet Tafesse, and Elizabeth Ann Watkins. Our paper explores a puzzle at the current moment of algorithmic accountability. Collectively, developers, regulators, academics, and community advocates have made rapid advances in understanding how algorithmic systems can pose systemic risks and cause harms. Yet there are few formal avenues to contest the development and deployment of any given system. The first law requiring fairness audits of machine learning models used in hiring goes into effect next month in New York City. A law requiring impact assessments of all sensitive algorithmic systems is currently under consideration in the California Senate, in addition to similar laws in the US Congress, which share features with the EU AI Act. There's now a clear momentum, at least, toward governance regimes centered on measuring how these systems function and assessing what their consequences are in the world. Yet that critical component of accountability ecosystems remain under-examined: contestation, or the right of the public to assert its interests over the design and or deployment of algorithmic systems. In particular, we are at a moment where the algorithmic accountability regime, or lack thereof, has created a system of incentivized ignorance that makes it nearly impossible for publics to contest potentially harmful systems. By incentivized ignorance, we mean that the regulatory and economic incentives currently align such that it is often better for a developer or deployer to not know if their system might cause harm in order to avoid liability or bad publicity. However, without any obligations to transparently assess the consequences of algorithmic systems, there is certainty that the public has little chance to democratically assert any values or agency over the design of the systems that impact their lives. Importantly, we are drawing on a concept of the public from philosopher John Dewey, who points out that there are occasions when an otherwise amorphous and unarticulated public organizes itself to express its interests in the face of problems that affect them. There are many possible publics that are brought together relationally. A familiar example from algorithmic accountability space of how publics can coalesce is the Atlantic Plaza Towers Tenants Association from Brooklyn, who joined together to fight against the installation of facial recognition security and entrance control systems in their buildings. This was not a group of people that had prior interest in AI governance, but was forced by circumstance to coalesce around the articulation of their agency in contesting how technological systems would shape their daily lives. We take it as a core motivation of AI governance to make many more such publics structurally possible, without prefiguring what those publics might want. A commonly used framework for understanding algorithmic accountability was first proposed by organizational sociologist Mark Bovins as a way to understand large institutions in US and EU democracies as, quote, a relationship between an actor and a forum in which the actor has an obligation to explain and to justify his or her conduct. The forum can pose questions and pass judgment, and the actor may face consequences, unquote. Bovins was interested in accountability as a way to describe any mechanism that makes powerful institutions responsive to their particular publics. As noted by Maranke Viringa in her 2021 fact paper, Bovin's articulation is especially apt in the context of algorithmic systems, and is particularly useful for understanding the regulatory state that is increasingly being turned toward the AI and data industries. However, as our paper explores, for algorithmic accountability, major questions remain for this dyadic formula. Most importantly, how the public can make demands upon the forum to justify the adequacy of its assessment processes and the robustness of its assessments. Particularly in a highly technical regulatory environment, actors and forums speak a common language that may not be accessible or legible to the publics which need to coalesce around algorithmic harms. Transparency documentation that is increasingly routine, such as model cards, were created for utility within an engineering and product design environment, not to facilitate democratic contestation over values and outcomes. We contend that a dyadic relationship between regulators, the forums, and developers, the actors, is inadequate for the purposes of algorithmic accountability precisely because it cannot foreground the interests of impacted communities and individuals. Extending the forum actor dyad, we suggest a third entity, the public and its collectivities implicated by algorithmic systems, which ought to be structurally positioned to hold the forum accountable. When actors are themselves tasked with implementing the oversight practices that are demanded of them by the forum, which is a common regulatory structure, regulatory goals inevitably shift toward the actor's own priorities. In our proposed triadic model, the public serves as a counterweighting third entity to this trend. Such accounting requires more opportunities to litigate the lived experiences of algorithmic systems, which implies more procedural access to courts. The underlying rationale of algorithmic accountability must be that developers and operators should be responsive to the people who are used or otherwise affected by their systems. Accountability resides in the relations between the developers, regulators, and public and its collectivities, not in the algorithmic system, nor in the developer's practices alone. A relational approach structures accountability around conditions of possibility for publics to emerge, cohere, and assert their shared interests to regulators and developers, who are then obligated to listen. Examining how digital harms can and cannot be heard in courts currently illustrates the importance of establishing a triadic accountability relationship in the regulation of algorithmic economies. In the modern regulatory state, contestation over the development of technological systems often takes place within the context of contestation over the formal structures of accountability, whose interests get heard, how they get heard, and when they get heard. Thus, courts are an essential aspect of any mature algorithmic accountability regime, but currently courts are the primary blocker to achieving algorithmic accountability precisely because it is so hard to achieve standing for any type of digital harms, due in large part to the model of incentivized ignorance that we have identified. In the US, the right to stand before the court and have one's grievances against another party considered is guaranteed in the Constitution, as long as the claimed harm meets certain standards. Yet, privacy law experts have pointed to the thicket of sometimes contradictory legal precedents, standards, and taxonomies that limit plaintiffs' capacity to reach standing or redress in digital harm cases. Privacy harms, which share a family resemblance with algorithmic harms, can be diffuse, speculative, and downstream, yet standing requires material events that injudiciously limit plaintiffs' options for recourse. This implies legislators will need to statutorily recognize new categories of rights around information technologies, which it turns out is a rather tall burden. In our paper, we show how these challenges for standing play out across three types of algorithmic harms. For the sake of brevity, I will briefly consider only representational harms. In the case of Newman v. Google and YouTube, Black content creators associated with the Black Lives Matter movement sued YouTube for flagging their content as inappropriate and placing them under a so-called restricted mode, which blocked minors from viewing their videos and removed the possibility of monetization. The plaintiffs claim that YouTube's flagging of their content constituted harm on the grounds of racial discrimination and false advertising. In Davino Group v. Google, a group of LGBTQ plus content creators raised quite similar concerns. In dismissing these cases before any jury trial, the courts ruled that it could not consider the cases, largely due to the plaintiff's inability to provide the necessary types of evidence to achieve standing. These cases highlighted that regardless of the merits of any case, the current state of incentivized ignorance makes it nearly impossible for publics to cohere around formal accountability for algorithmic harms, regardless of their lived experience. The central task of governing algorithmic systems in the public interest is determining what type of algorithmic transparency regimes would therefore provide publics with the requisite knowledge to contest the harms that they identify. Efforts to cohere publics around algorithmic systems have drawn on regulation and case law for environmental harms, for public nuisance, and regulation of food, drugs, and cosmetics as suitable precedents. This diversity of analogous governance regimes is held together by the common feature of having to grapple with uncertainty around establishing causes and consequences. Along these lines, algorithmic impact assessments are increasingly being invoked as an appropriate mechanism when there are diffuse, probabilistic, and potentially novel forms of harm, and many intersecting interests implicated in a proposed development or deployed system. Inferring from other domains of impact assessments, AIAs have the potential to partially address the challenges of building capacity for algorithmic accountability. Where courts now refuse standing for algorithmic harms, an AIA regime may create procedural rights that can protect the substantive rights that courts have so long struggled to recognize. Making algorithmic harms more cognizable to courts shifts the field of relations to be considered in evaluating the impacts of a system. It fosters norms that developers need to attend more closely to its possible harms and provides a backstop for impacted publics to seek due process and remedies. While there are plenty of reasons to be skeptical of any algorithmic accountability regime, built on transparency documentation, that it will alone move power away from developers. What it can do is establish the possibility for informed contestation, structuring an accountability relationship between actors, forums, and publics that does not currently exist. Thank you for listening to our paper. We look forward to any questions.